My passion for DUI law comes from how I see the DUI laws enforced. I think that they're enforcing them in a very heavy-handed way and in a way that attacks some pretty cherished American values. For instance, the law assumes that we give our consent to have our blood, breath, or urine tested, and if we do not comply, the state, prior to any conviction, seizes our license. I think that's a very important attack on the principle that we are innocent until proven guilty in a court of law. We also see roadblocks, DUI checkpoints, where there is no probable cause required to pull you over and investigate you. The state simply does it and allows it. We don't stand for that in any other circumstance, but we do allow it in DUI law. In 1984, the Supreme Court of Ohio adopted a case called State v. Vega. And in State v. Vega, they've essentially said that the DUI attorney cannot go into court and challenge the science or the methodology that the state of Ohio has adopted for breath testing machines. That's essentially equivalent to saying in a capital murder case that a defendant doesn't have the right to challenge the DNA science or any eyewitness identification science. We think that's wrong. I've been fighting for all of my career to overturn State v. Vega, and I'll continue to fight for it. The other thing that we see is that the law is used in a very coercive, intimidating way. Under certain circumstances, the state of Ohio has adopted a law that says they can allow forced blood draws. And those forced blood draws, the state is allowed to hold you down, and the law actually says by any means necessary. By any means necessary is a standard that we've adopted. Now I think if you're going to hire a DUI attorney, you want a DUI attorney that's going to go in and fight by any means necessary to fight as hard for your freedom as they're fighting to convict you.